Good afternoon. My name is Phillip Montgomery, and on behalf of CBIA, I would like to welcome you to our presentation on the CARES Act and employee benefits. CBIA is the leading voice for business in the state, representing thousands of member companies, large and small, across a diverse range of organizations. During the COVID-19 crisis, we have been pleased to keep our members aware of the various legislative actions enacted as a result of this pandemic. In that light, we are delighted to have Virginia McGarrity and Alisha Sullivan of the law firm Robinson and Cole to speak to the impact of the CARES Act on employee benefits. Virginia McGarrity is a member of the firm's Employee Benefits and Compensation Group, counseling employers, insurance carriers, and service providers on a wide range of complex employee benefits and executive compensation matters, including retirement plan design and administration, health and welfare benefits, executive compensation and equity arrangements, fiduciary advice. She's a graduate of Penn State University of Dickinson School of Law and is a member of the American Bar Association, the Connecticut Bar Association, the Connecticut Hispanic Bar Association. She has been selected by her peers for inclusion in the best lawyers in America in the area of employee benefits law since 2018. And she has also been selected to the Connecticut Super Lawyers list from 2013 to 2019. She is joined by Alisha Sullivan, who's also a member of Robinson Cole's Employee Benefits and Compensation Group. She focuses her practice on counseling a wide range of clients on issues arising from the creation and administration of employee benefit plans, including all aspects of plan design and administration, adhering to ERISA, the Internal Revenue Code, and other applicable laws and plan compliance and correction issues. She is a graduate of Western New England Law School, and she's a member of the Connecticut Bar Association, American Bar Association, the Massachusetts Bar Association. She has been listed as a rising star in the 2018 and 2019 Connecticut Super Lawyers list, and she's also in the Connecticut Bar Association Young Lawyers Section Star of the Year Award 2017 to 2018. Please join me in welcoming Virginia McGarrity and Alisha Sullivan.
Thank you, Phil, and thank you to the CBIA. I'm Virginia McGarrity, and I'm going to start off talking about the CARES Act and its impact on employee benefit plans. A quick overview of the CARES Act. It was signed by President Trump on March 27th, 2020, and it was a bipartisan deal that dealt with a little over $2 trillion stimulus package to aid certain businesses, workers, and healthcare systems that were deeply impacted by the global health pandemic. It also followed closely on the heels of the enactment of the Families First Coronavirus Response Act, which was signed into law on March 18th and provided for emergency paid family leave and emergency paid sick leave for certain workers. So there are key employee benefit provisions that were included in the CARES Act, among many other aspects covered. And these provisions impacted a variety of employee benefits, ranging from health and welfare plans to retirement plans to addressing student loan assistance programs that are provided by employers, as well as payroll tax relief for certain businesses. It also provided for a more generous unemployment insurance benefits and made modest clarifying changes to the FFCRA. All of these issues we will be covering and highlighting today during this presentation, starting with the retirement plan provisions. Now, it's important to note that the retirement plan provisions will require amendments to your retirement plans should you choose to enact them. The amendment deadline has been extended out to December 31st, 2022 for calendar year plans. And if you happen to be a governmental or municipal plan sponsor, that deadline was extended out even further by an additional 2 years. So we definitely have time to make these plan amendments, and most clients are waiting to formally draft the amendments with the help of their advisors and legal counsel as we're waiting additional guidance. But these provisions are available today, so that's an important thing to keep in mind as we're going through this. So one of the first changes we're going to talk about deals with participant loans. Participant loan programs are not required by ERISA or the Internal Revenue Code. These are optional features that you can have in your plan. And for those plan sponsors that do have participant loans, the CARES Act did expand the plan loan provisions to increase the maximum loan amounts available to your participants. So prior to the CARES Act, the IRS Internal Revenue Code established a limit of $50,000 or 50% of the participant's vested account balance as being available for a loan. And the CARES Act dramatically extended it, essentially doubled it, to $100,000 or 100% of the participant's vested account balance. This would be available for any loans that were issued to participants between March 27th, the date of the CARES Act enactment, through September 23rd, 2020. There is a little bit of a tension here, I will note for you all, because while the Internal Revenue Code was amended by the CARES Act to increase the limit to 100% of the vested account balance being available to participants, participant loans are also governed by ERISA, and ERISA requires that there be adequate security for the loan, and that the adequate security cannot represent more than 50% of the vested account balance. So there's a little bit of a uncertainty here as to whether or not, if you were to expand your loan provisions as permitted by the CARES Act, whether that additional 100% of the participant's account balance being available would require the participant to put up some other form of security beyond their vested account balance. Some clients we have are waiting for additional guidance on this particular issue. Others have chosen to enact it as available under the CARES Act. And a few others have asked their record keepers and third-party plan administrators to allow for the $100,000 expansion, but to keep the limit at 50% of the vested account balance. So that is something that we're waiting on additional guidance. These increased participant loan amounts and also the hardship provisions that we're going to be talking about in the next few slides are available to what's called qualified individuals under the CARES Act. So qualified individual is a participant, his or her spouse or dependent, who's been diagnosed with the virus by a CDC and prevention-approved test, or it could also be a participant who suffered financially due to a layoff, furlough, quarantine, or reduced hours worked as a result of the pandemic. It's also available to a participant who cannot work due to the unavailability of childcare, again, due to the pandemic. And it can also be available to a participant's business if the participant had business that had to close or operate under reduced hours. So it's pretty broad with respect to who is a qualified individual. And the CARES Act does allow the plan participant to certify his or her own eligibility as a qualified individual under any of these conditions. Plan sponsors are not required to confirm the person's certification or request additional documentation. So you're really taking the participant at his or her word that they meet the criteria as a qualified individual for these various relief measures that we're speaking about today. In addition to increasing the participant loan amounts, the CARES Act also provides for delayed loan repayments. So if your plan currently offers participant plan loans and a participant has a loan outstanding and they have repayments due anytime between March 27th to December 31st of this year, the CARES Act delays the repayment terms for 1 year from the original due date. This is a mandatory provision, so if you do have a plan loan provision in your plan, you are required to make this 1 year extension available for loan repayments, but it is at the participant's request, so a participant does have to request the extension. And as many of you know who have dealt with plan loans, typically, a plan loan is limited to 5 years from the original date of the loan, unless you're using the loan to purchase a primary residence. And so this 1 year extension essentially goes past the 5-year term limit, and that's been okay, and it's approved by the CARES Act. So a 5-year term limit will be turned into a 6-year term limit with this provision. And again, it's a mandatory provision if you have loans in your plan, and it's available to all qualified individuals. Probably one of the most popular provisions of the CARES Act as it impacts retirement plans has been the coronavirus-related hardship distribution. This allows the qualified individual to take a distribution of up to $100,000 from his or her plan account without imposing a 10% penalty for being under the age of 59 and a half. Any amount that is received as part of this hardship distribution needs to be available to be repaid to the plan within 3 years if the person so chooses, and it's going to be treated as a rollover contribution for that purpose. Any amount that's required to be included in the gross income of the individual will be included ratably over a 3-year period unless the participant elects to have it taxed in the year of the distribution. And again, employers and plan sponsors can rely on the individual's self-certification that they are a qualified individual. At this point in time, most plan sponsors would have been contacted or will have received some sort of communication from their TPAs and record keepers about these various provisions. Again, this coronavirus-related hardship distribution is very popular, and many of the larger TPAs, this was sort of the first thing that they've rolled out, followed closely on the heels by the plan loan provisions. In addition, the CARES Act delays the required minimum distributions required by the various plans at issue here. So in essence, the CARES Act allows defined contribution plans, specifically 403B plans, 457B plans, 401A plans, 401K plans, to suspend making required minimum distributions to any individuals who would otherwise be required to receive the required minimum distribution, or RMD, in 2020. This suspension also applies to individuals who actually turned 70 and a half in 2019, but hadn't yet received their 2019 RMD. This is an optional provision under the CARES Act. And with that, I will turn it over to my colleague Alisha to talk about several of the health and welfare related provisions of the CARES Act.
Code Section 127, educational plans. So Code Section 127 generally permits an employee to exclude from his or her gross income amounts that are paid by their employer for educational assistance. This section previously had a sunset provision, but in 2013 became a permanent exclusion by the American Taxpayer Relief Act of 2012. So employers are rather familiar with these plans at this point since they have been around a while. Code Section 127 plans provide education assistance to employees by employers that adopted this type of plan up to an annual maximum exclusion of $5,250, but they're only permitted to cover things such as tuition, fees, books, supplies, and equipment. So while employers do have some flexibility over the design of their plan, such as those employees that are eligible to participate, of course, subject to certain non-discrimination rules, minimum performance standards, and whether or not to require the reimbursement of expenses paid if the employee voluntarily terminates employment. Employers have not really had much other flexibility with respect to the expenses eligible for reimbursement, other than those that are specifically listed in Code Section 127. And student loan debt is generally, it has been receiving a lot more spotlight recently. Employers have been looking for ways to provide a benefit to help their employees relieve some of that debt. However, due to Code Section 127's restrictions, up until now, this really has not been an effective method of doing so. So moving on, the CARES Act from March 27 to December 31st of 2020 expands Code Section 127 to allow employers to reimburse employees up to the maximum exclusion amount of $5,250. Under the new law, payments must be for student loans that are incurred for the education of the employee, so they cannot be for student loans of the employee's spouse or of the employee's student. And all other rules of Code Section 127 do apply. So if you are going to be making these types of student loan payments on behalf of your employees, you still have to have a written plan document. You have to ensure that the plan does not favor highly compensated employees, and so on. It's rather unusual for this provision to have been included in this bill, since right now most employers are looking for ways to save on expenses in the current climate. However, some people are starting to speculate that advocates of this type of change may lobby Congress to make it a more permanent change. Separate and aside from the employer's options regarding employee student loan debt, many federal student loan borrowers are also able to suspend their monthly payments through September 30th of 2020 without any interest accruing. Therefore, any payments that are made during this time will likely have a much bigger impact on the student loan debt. The CARES Act also made changes to several health and welfare provisions. So I'll run through these changes rather quickly, as I think they've been pretty well publicized, perhaps more so than some of the other provisions of the CARES Act. So the CARES Act did create a new safe harbor that allows employees that are participating in a high deductible health plan with a health savings account, commonly referred to as an HSA, to receive telehealth medicine before having to meet their deductible or free of cost sharing. And that's for plan years beginning on or before December 31st of 2021. The Affordable Care Act's ban on pre-tax reimbursement of costs for over-the-counter medical supplies not prescribed by a doctor, such as drugs and surgical masks, is lifted. And individuals can also now use HSAs, health reimbursement accounts, healthcare flexible spending accounts to pay for menstrual care products. And both the lift on the ability to use these accounts for over-the-counter medical supplies, as well as the ability to use these accounts for menstrual care products, are effective for expenses incurred on or after January 1st of 2020, and they don't have an expiration date. So we do anticipate these will remain to be permanent changes. Initially, under the Families First Coronavirus Response Act, the FFCRA, all group health plans were required to cover COVID-19 or coronavirus testing and related services without cost sharing and without imposing prior authorization or similar standards. That coverage mandate initially took effect on March 18th of 2020, and the CARES Act just further refined that coverage mandate to set forth rules for reimbursing healthcare providers for testing and related services. It also requires health plans to provide cost-free coverage of any qualifying coronavirus preventative service, such as those that are recommended by the U.S. Preventive Service Task Force or from the CDC. So that would include things like a vaccination. Some of the other benefit plan provisions affected by the CARES Act deals with the funding of defined benefit plans. So plan sponsors of defined benefit plans are able to delay the minimum required contributions that are due during 2020 to January 1st of 2021. Interest will accrue during that period from the original due date up until the payment date. So effectively, those contributions that are attributable to 2019 but that are actually due in 2020 may be delayed. However, at this time, it doesn't appear that those amounts that are due for 2020 but that must actually be contributed in 2021 may be delayed. And this is an optional provision, and therefore plans may still elect to make the minimum required contribution in 2020 if it so chooses. Those businesses that receive direct loans or loan guarantees are also going to be subject to compensation-related criteria. So the CARES Act caps the total compensation, including salary, stock, and bonuses, for any employee that makes over $425,000 in total compensation of their 2019 pay, and also excludes compensation determined by collective bargaining agreements entered into before March 1st, 2020. Additionally, for 12 months after the expiration of the loan or loan guarantee, the business is prohibited from reducing its workforce by more than 10%, as well as buying back its company stock, paying dividends, or making other capital distributions. Additionally, for those businesses employing between 500 and 10,000 employees, the CARE Act does require that 90% of the workforce be retained with full compensation until September 30th of this year, or if layoffs have already occurred, that the business restore at least 90% of its workforce that existed as of February 1st, 2020, and they must be restored with full compensation and benefits no later than 4 months after the termination date of the public health emergency. Certain employers are also eligible for a refundable payroll tax credit and wages paid up to $10,000 during the pandemic. And this credit is available to employers whose businesses were disrupted due to virus-related shutdown or that had a decrease in gross receipts of 50% or more as compared to the same quarter last year. The credit can be claimed for employees who are retained but not currently working for businesses with more than 100 employees, and for all employee wages for businesses with 100 or fewer employees. Employers can also delay the payment of the employer share of Social Security payroll tax due to the remainder of the year and pay back the liability, with 50% of that amount being due December 31st of 2021 and 50% being due on December 31st of 2022. So that can actually end up being quite a substantial amount. And then lastly, most have already heard about the expanded unemployment insurance provisions, and which basically allow many individuals on unemployment in a number of states to now be receiving an additional $600 on top of whatever state unemployment benefits they are otherwise already entitled to. So moving on, we just want to touch on a few benefit plan considerations. When faced with furloughing employees on the health and welfare side, employers are considering whether this will cause the employee to have a COBRA qualifying event if there's a loss of health insurance, or whether employees are permitted to make mid-year election changes, such as changes to their dependent care, flexible savings accounts if they're no longer having a child in daycare, and permitting furloughed employees to remain on active employee health coverage or payroll.
That's right, Alisha. On the retirement plan side, the same sort of considerations with respect to furlough of employees could have a big impact on your benefit plans. You have to consider a furloughed employee is technically not a termination of employment. It's almost like an unpaid leave of absence, if you will. And so it doesn't trigger a distributable event from a retirement plan. But there are other considerations. For instance, if you do have a loan program and somebody is placed in furlough, has an active loan outstanding from the plan, you have to look at whether your plan allows the person to repay the loan outside of automatic payroll deductions. You also have to consider whether your plan documents and your procedures allow for a furloughed employee and a participant to apply for and receive a loan or a hardship. There's also the question about service crediting. Depending on the plan design, an employee who's furloughed would continue to receive service credit for purposes of eligibility and vesting, but they may not. And then in addition, there are questions about the employer contributions during that time, because a furloughed employee is obviously not receiving pay, would not be contributing actively to the retirement plan, and therefore wouldn't be eligible for an employer matching contribution, for example, but they could still be eligible for other types of contributions, for instance, if you have a profit sharing contribution. So all of those things really do have to be looked at very carefully on the retirement plan side and as well as on the health and welfare side, as Alisha mentioned. You also have to think about cost-cutting measures. Many employers are looking to either reduce, suspend, or delay employer contributions to retirement plans at this time. And you have to look again at your plan language. In most cases, it'll likely require you to amend the plan to provide the change to the employer contribution. And if you are a safe harbor plan design, you will have to provide advance notice of the change. And then you will also be subjecting your safe harbor plan to now being subject to the ADP, ACP non-discrimination test. So there are quite a range of implications and measures that have to be taken when you're looking to reduce, suspend, or delay employer contributions, as well as just providing notice to your participants and employees of those changes. One last thing we want to point out is that you could trigger what's called a partial plan termination. If you have more than 20% of turnover of your participants in your retirement plan, that will trigger a partial plan termination. And this is especially important to keep in mind in the context of layoffs, because if you trigger a partial plan termination, again, with more than 20% turnover of participants in the plan going from active to terminated, you will be required to 100% vest all of the affected employees through the partial plan termination. So it could end up getting quite costly for some employers if they're not thinking about these things. And with that, we'd like to open it up to questions.
Thank you very much, Virginia and Alisha. I do have a few questions, if I may. First one, do I have to permit my employees to take loans on hardship withdrawals from the retirement plan?
So the answer is no. You do not have to allow plan participant loans or hardship withdrawals. Those are optional provisions, and the CARES Act did not make them mandatory. The only mandatory change touches on loans. So if you already have opted to have a loan provision in your plan and you have a participant with an outstanding loan, again, you are required to allow them to do a one-year suspension or delay of their loan repayment terms. But again, that's the only mandatory provision. You do not have to offer loans. You do not have to offer hardship or any other in-service withdrawals under the terms of your plan, and the CARES Act doesn't change that.
Thank you very much. I do have a couple more. Due to a reduction in hours scheduled to be worked, our company believes that many of our employees will have insufficient compensation to cover the cost of their benefit selections. How do we handle the collection of premiums?
Yeah, thanks, Phillip. So generally employers have, three options for collecting premiums. The first being to have employees prepay, the second being to bill those employees directly, and the third being to cover the premiums on behalf of the employee and then seek recoupment from the employee once they return back to work. Those employers that do elect to cover the premium for employees and seek recoupment should just be mindful that there may be relevant and applicable state wage and hour laws, as many states do regulate when and what deductions may be taken from an employee's pay. Lastly, whichever method is implemented by the employer should be applied uniformly among all furloughed employees. Specifically, FMLA requires that whatever payment options are available to employees in FMLA leave should be at least as favorable as those options available to employees on non-FMLA leave. So employers may consider whether it makes sense to coordinate with its FMLA policy to ensure that the payment of premiums for those employees that are furloughed are not more favorable than those that are on FMLA leave.
And I'll just add that in terms of what we've seen for our clients, the most popular method typically has been a pay-as-you-go method. So in other words, the employee is paying after tax and remitting their premiums during the furlough period, and they're either sending it directly to the employer or directly to the carriers. It depends on how it's set up. But also, whatever method the employer decides to elect, besides being sort of uniform in application and keeping in mind what needs to be provided for FMLA versus non-FMLA leave, communication to your employees is definitely a key here. You want to make sure your employees understand whether benefits are going to remain in place or not during the furlough and what they have to do in order to maintain those benefits and not miss any premiums, which could affect coverage.
Thank you. I do have one last question. If I decide to institute employee furloughs, the employees remain as employees, but are not asked to provide services for a period of time. What are the implications to our benefit plans?
Right. So it really runs the gamut, as we sort of talked about. On the retirement plan side, again, it is not a distributable event because it's not considered a termination. So you would not be distributing assets from the plan for these individuals on furlough, but you do have to look at what happens if they have an outstanding loan, how would they repay it, whether they're going to be eligible for loans and withdrawals generally when they're not necessarily actively at work or an active participant. and what's going to happen in terms of availability of employer contributions. And then on the health and welfare side, I think as Alisha has touched on, there's sort of the first question you have to ask yourself is, will the health and welfare benefits remain in place for furloughed employees, or whether they're going to be turned off? In a lot of cases, if you look at your individual plans and policies, there's either an active employment requirement for eligibility or a scheduled hours requirement, and obviously a furloughed employee would not meet those standards for eligibility of coverage. So the default in many cases is that the benefits won't be available on the health and welfare side for a furloughed employee. You can certainly work around that. You would reach out to your carriers and your administrators and adopt the necessary amendments to cover these furloughed employees. But for the fully insured policies, you definitely want to get the carrier's approval to do that. If you don't have carrier approval, or if you're not going to if you're not going to maintain benefits coverage during this time, just keep in mind that it would be a COBRA qualifying event for your health benefits. If it's life insurance that's going to be terminated through the furlough, you are going to have a notice of portability or conversion rights that the employer is going to have to send out. And outside of that, if benefits are going to remain in place, just keep in mind, as Alisha mentioned, how you're going to be collecting premiums during that unpaid period of the furlough. And if benefits stay in place, it's not a mid-year election change or a qualifying event that would allow participants to elect changes to their benefits. But these are all issues that you need to, again, look to your plan documents, look at your policies, talk to the insurers to get carrier approval where needed, adopt the appropriate amendments, and talk to legal counsel, because there is quite a bit of work there with respect to benefits and how you treat them during furloughs.
Great. Thank you very much, Virginia and Alisha. That presentation was very informative on a very complex and challenging law for employers. We very much appreciate the time you've given to us, and we ask our attendees that if they'd like further guidance from Virginia or Alisha, please do not hesitate to reach out to them. You can see their contact information on their screen. Finally, on behalf of CBIA, thank you very much for spending this time with us, and have a good one.